Good afternoon or good morning, depending upon which time zone you're in. I'm Mary Guzman, and I am the chair of the Trade Secret Committee for the USIPA. And we're really excited to be bringing some educational content to you this morning around sort of the shifting landscape in trade secrets and intellectual property in general. There seems to be a move afoot around trying to keep things secret rather than necessarily patenting things for a lot of different reasons. And there are some regulatory changes going on, not just in the US, but around the globe, around managing trade secret assets and how the litigation seems to be shaking out and working. And we're going to talk about all of those things today. And I'm extremely excited to be joined by David Pardue and Nick Armington, who are both fantastic trade secret consultants and litigation attorneys. You can read their bios and see who they work for in the information that's been provided. And we also have at the end of the presentation a slide deck that has all of our contact information. But with that, I think we're going to go ahead and get started. Next slide, Nikki. So we already kind of ran through what we're going to talk about. One thing I didn't mention is the SEC cybersecurity disclosure rule, which we'll touch on a little bit because I think that's something that gets lost on a lot of people when they think about implications for trade secrets when they're exfiltrated during a hack. Everything else is pretty fairly easily explainable. Next. When we think about trade secrets in terms of the overall IP landscape, as opposed to patents, copyrights, and trademarks, which are all registered and therefore publicly available intangible assets, trade secrets are all of the stuff that's under the surface, but is nonetheless very important. And when we talk to clients about what their exposure is to trade secret misappropriation and helping them try to get their arms around what this risk looks like, it can feel a little bit overwhelming because a trade secret can literally be almost anything. As long as it's independently developed, it gives you a competitive advantage because of its secrecy, and you're putting specific protections around it to keep it secret. David is or Nick will chime in on various parts of the conversation to share their insights around what ends up being reasonable measures. That's always kind of what trade secret litigation hinges on, or whether or not you even had a trade secret in the first place. But one thing that I wanted to touch on before I pass it over to Nick is a lot of companies or a lot of people that we talk to don't realize that two things. One is that virtually everything in a company's R&D pipeline is a trade secret, or at least those that are in the later stage that are already showing promise and value. And so if you think about organizations that are spending upwards of 15 to 20% of their revenue annually on R&D, and that's what they're getting their capital and fundraising money for, is to continue to do research and development, that's a rather staggering statistic or opportunity there. The reason that trade secrets, that R&D is full of trade secrets, is because nothing is published yet. And there needs to be a strategic decision made at some point as to whether or not to go ahead and file for patent protection, for example. But until then, the day before a patent becomes public, the information could theoretically be a trade secret as long as it meets the other criteria, meaning reasonable measures have been applied, et cetera. The other interesting thing about trade secrets is that many of them are created outside of engineering or R&D. So there are a lot of things, business processes, algorithms, generative AI output that are outside of what you would normally think of when you're asking your organization to create a competitive advantage for you. And some of them are created over years and years of wrong turns or negative know-how that lend themselves to a better, faster, delivery mechanism or a value proposition for you. So with that, I'm going to turn it over to Nick, and he's going to chat with you a little bit more about trade secrets.
Thank you, Mary. And thanks to all the participants for joining us, and to the USIPA for hosting us today. So as Mary mentioned, I'm a trade secret litigator and also a patent litigator, and really excited to be here talking about one of my passions. So Mary mentioned as well, trade secret protection can cover an incredibly broad scope of information, right? So a trade secret is any piece of information that is economically valuable, because it is not generally known and cannot easily be ascertained, and for which reasonable measures have been taken to protect that information. So there are some kind of classic examples that you hear over and over again. But I think you hear them because they're pretty good touchstones. So I'm going to use them as well. So one you hear is the Coca-Cola formula, right? Coca-Cola is the only company that has that particular specific formula. They've done a pretty good job of keeping it secret for over 100 years. And because they've done that, and no one has been able to reverse engineer the Coca-Cola soft drink, meaning taking a bottle of Coke, pouring it into a beaker, analyzing it, and determining exactly what the ingredients are, how much of each ingredient is included, and what the process is for combining them. Coca-Cola is still the only company who can really make the original, right? So it's one of those classic examples, but it's so good because it's so simple. The other one you hear is Google source code, right? A lot of Google source code is actually available, but the real crown jewels, as I'll put it, are not. And there's a reason they're not, because they're so incredibly valuable. And no one has been able to reverse engineer them, right? So you're seeing the repeating theme and the repeating elements of what a trade secret is. But it's not just that highly technical information or recipe. It can be something as non-technical as a customer list. Now, you might call that a non-technical or a soft trade secret, but that doesn't mean it has no value. For many companies, the customer list is one of the most valuable pieces of information they have, and if appropriately protected, is a trade secret, and cannot be disclosed. And if it is improperly disclosed, that disclosure can be addressed through litigation. And I think we'll get there. But the main, the first message here is that every single company in the United States has trade secrets. I say that with confidence. But I'll tell you, I think 95% of the companies in the United States are not thinking about trade secret protection, and not taking, what are relatively straightforward protocols to protect trade secrets. But with that effort, this highly valuable information, it might be the most valuable asset class for companies in the United States, can be better secured. So I think that's the message, one of the messages we're trying to get out here. So I'll talk really quickly on this slide and talk about the differences in IP protection, very quickly, because we could spend all day on any one of these. You think of kind of four aspects of IP protection. They're on the slide: patents, copyrights, trademarks, and trade secrets. And they all provide slightly different protection. And I'm not going to spend too much time going into the protections of each, because again, that would take our whole hour. But I would like to emphasize that trade secret protection is the only type of IP protection where you don't need to give anything away. You don't need to give anything to the public. When you get a patent, you are obligated to disclose your invention to the public, and the public will be able to use it eventually. It's just a matter of time. And all a patent gets you is the ability to exclude individuals from using your invention. It doesn't give you the right to use it, actually. So when thinking about getting a patent, you need to think about, am I going to get value out of my invention in the limited time period that I can exclude others from using it? because after that term of the patent is over, the public owns your invention and can use it as they would like. Same with trademark. Trademark and trade dress essentially identifies the source of goods, but you're giving to the public your brand, right? That is available publicly. You're not keeping any information confidential, and so too as to copyright. Copyright gives you the ability to limit essentially exact copies or very close copies of creative work embodied in a tangible medium. It is the parlance of copyright law. But there's still abilities for the public to use your copyrighted material through a doctrine called fair use. So the public can use your copyrighted material once you put it out in the public. It's just a question of how much they can use it. So trade secret is distinct in that your information is kept secret if you take the appropriate measures to keep it secret. And I think the key there is that those measures should not be and will not be overly burdensome because they are reasonable in light of the circumstances. So the measures that Coca-Cola has to take, a massive corporation, are actually different than the measures a 5-person or 2-person startup needs to take. It needs to be reasonable under the circumstances. So for any company of any size, measures can be taken to protect trade secrets that are not overly burdensome or overly expensive for that company. So it's an important type of protection to keep in mind, and that's why we're kind of singing the gospel here. And I'll make one more point before I move on to international protection, and that's trade secret protection. I don't think should be thought of as just a prophylactic measure to keep things secret. I like to think of trade secret protection, one, to keep those most valuable crown jewels secret, but two, to give you the ability to leverage your IP assets. So another big part of my practice is IP counseling and helping companies take their IP assets, not only be able to use them, but drive capital from those assets. And in some circumstances, that means licensing and sale of trade secret assets, which is something I do quite a bit. But what companies don't often do, when I enter the picture, I find that they haven't yet specifically identified their trade secrets and identified the protections that have been taken to keep them secret. If you haven't done that, you cannot license your trade secrets. And it's not a difficult process, but it is a process you need to undertake before you derive any sort of economic value from your trade secrets. And I know we'll talk about it more. I call it trade secret asset management. I think Mary has a similar term, and she'll tell us about that. But, my last point on this slide, trade secret asset management, the thought of protecting trade secrets using the laws, I don't like to think about it as a cost center. I hear a lot that legal is a cost center, but, trade secret asset management protection is not. What it is identifying IP assets so you can leverage them and drive revenue and make that go directly to your company's bottom line. So that's all I have on this slide. And I can move forward, but if Mary or David have additional comments, I can open the floor.
Let's go ahead, Nick, because we got a lot of slides to get through and we're already 15 minutes in. I know we could spend any one of these.
So I'll go through the next one really quickly.
Yep.
We could go to the next slide, please. Okay, so turning back to kind of addressing when a trade secret has been taken. Sometimes you undertake the best methods you can to protect your trade secrets, but they are misappropriated anyway. Often you see it with an employee leaving to go to a competitor or start a competing business, or where there's a joint development program between companies, and one company uses information that it shouldn't, essentially, after that program is complete. Now, as the world gets smaller, often these sorts of things happen on an international stage. But thankfully, there are protections in place to address what we'll call, extraterritorial misappropriation of trade secrets or trade secrets by foreign actors. So first, under the Federal Trade Secret Act in the United States, the act can be used to address trade secret misappropriation that has taken place, at least in part, abroad, right? And this has recently been affirmed. We've got a little box on the bottom right of this slide by the Seventh Circuit in a case that came from the Northern District of Illinois that found trade secret misappropriation by a foreign actor in Malaysia, essentially, relating to it was essentially digital radios, trade secrets related to digital radios. And the district court a number of years ago found that the DTSA can have extraterritorial reach, but just recently the Seventh Circuit Court of Appeals affirmed that, and other courts across the United States have followed this opinion as well. So quickly, the DTSA can address trade secret misappropriation when it takes place abroad. In not every circumstance, there are some limited circumstances. One where a citizen or a permanent resident of the United States is the offender. If it's a United States corporation that's being accused of trade secret misappropriation, or an act in furtherance of trade secret misappropriation has taken place in the United States. So you can think of, there's actually a pretty good recent example of this on the screen too. An individual in the United States working for an American company has put a thumb drive into a computer and taken some of the, 1,000 of the most trade secret files and hopped on a plane to China. In that circumstance, the argument would be, well, there's an act in furtherance in the United States. The individual in the US stuck the thumb drive into the computer and then absconded to another country. And you hear about these every so often in the news. And, sometimes the FBI is there waiting at the airport to pick them up. And that's when you see the news article. They're pretty good at finding this stuff. And kind of the one article here, which is really interesting, there's a Silicon Valley firm that's being accused of essentially siphoning trade secrets, got through preliminary business conversations with companies they purportedly may invest in, collecting that information and then kind of siphoning out of the country. And you can see how that would be a very beneficial and lucrative operation for whoever's really running it, right? But it's just an example of how there are many kind of avenues for trade secret information to be siphoned away from their owner, and just kind of goes back to the importance of putting appropriate protections in place so that
Nick,
doesn't happen.
Just for a second about that particular issue. I posted about that a week or so ago about the VC firm Hone Capital being investigated by the FBI. To me, that is an absolute game changer in the industry, because I don't think that a lot of organizations would expect that their venture capital partner or somebody that they gave their pitch deck to would turn around and give that information to a different, nation state or foreign financial backer. In the VC world, it's very common for venture capital firms to sort of refuse, I'll say in a nice way, to sign non-disclosure agreements, because it's time consuming and they look at, hundreds of deals a year. And so they tend to push back hard on having to do NDAs. Obviously, that is a huge problem, and we have something that we have to fix. And VC firms really need to have a one and done, take it or leave it approach, perhaps, to what's in their non-disclosure agreements. And even though the company might not be giving them their Coca-Cola formula or the Google algorithm actually in their pitch deck, they will be talking about their strategy for rollout, their distribution strategy, what products they plan to develop, by when, and with using what resources, what their financials expected to look like. Those are all trade secret information if they're protected properly, because they're valuable competitive advantage for you as a company.
It's so true. And it's just, it's one of the continuing kind of lexicon of creative ways in which trade secret information can leave companies. But again, there's a relatively easy way
Yeah.
to prevent that, and it doesn't take a lot of work. But I know that most of the companies in the U.S. are not thinking about it, which worries me. But it's
Yeah.
why we're here, to kind of get the word out. So I'll just spend one more minute on this slide and then pass it on. I want to talk about trade secret protections under foreign law, essentially. I'll talk first about China, because there are concerns about trade secret information going to China and its use in that country. Now, for a long time, the Chinese law was difficult to utilize to address trade secret misappropriation. That's recently changed in the last 2, 3, 4 years. China they've reversed the burden of proof in trade secret cases. So it used to be that the plaintiff had the burden of proof. However, there's no real discovery in China like there is in US litigation. So the plaintiff really had to have everything lined up when they brought the case. And that can be difficult when you have imperfect information as to how the defendant is using your misappropriated trade secret. When that did work, and I had one of these cases, is when you had a case in the US first, where you got discovery about how the trade secret was being used in China. And then you can leverage that in your Chinese action. And that can be quite successful. But if you don't have that discovery already, it was very hard. And Chinese courts also, historically were reluctant to issue large damages awards. Those two things have changed. It's now the defendant's burden, essentially, to rebut once the plaintiff has made a preliminary showing of trade secret misappropriation, which is a much lower bar. And now Chinese courts are, under statute, much more able to issue willfulness awards for damages, which can be much bigger. So it's still early in this process, but it's potentially a sea change. And we have seen some a greater number of trade secrets decisions coming out of China in the last couple of years. So I think that's encouraging. I think they're headed in the right direction.
Excellent.
And just generally, in Europe, for instance, there are also trade secret protections. Those are more akin to the federal statute here in the US, and the requirements for what qualifies as a trade secret and what reasonable measures you need to take to protect them are, they're not exactly the same, but when you're thinking of it as a high level, it is much closer. So understanding the jurisprudence in the United States is a good start to understanding what protections you may have in Europe and other Western countries. So with that, I think I'm going to pass it on, unless there are other comments or questions here.
So let's talk about navigating some other kind of regulatory waters. I'll do this quickly, but essentially one of the things that I think a lot of folks have sort of not paid enough attention to is the fact that the SEC cybersecurity disclosure rule, which passed in December of last year, so it's already in effect, requires a lot of transparency around any disclosure of an asset or basically an outage, downtime, whatever it is that could cause a material impact to earnings, quote unquote, of a public company. And so they're wanting organizations to disclose straight up in their 10Ks what they're doing to mitigate exposure to material assets around misappropriation. Number two, if there is a happenstance or a circumstance where information that could drive a material impact to earnings is disclosed, you have an obligation to file an 8K within 4 days of determining that that incident reasonably could have a material impact. And the bar for reasonable impact, material impact, is very low. If you follow, it does not just say exactly what material is in that SEC rule, but if you follow what CISOs and other, sort of chief, technology and information officers follow under NIST and a lot of other guidelines, it's only like 5% of earnings or 1% of revenue, or I may have that backwards. You can fact check me on that, but it's a very low bar. So if you've got a crown jewel trade secret that goes missing, basically you have an obligation now to disclose that to your shareholders. And I don't think, well, we know for a fact that most companies are not doing that. There have been 40 something companies that have filed 8Ks following a disclosure since this act went into effect, or since the rule went into effect. Several of them have talked about senior leadership emails being compromised. Some of them terabytes of data. What was attached to those emails and what was the source of those emails? If they're talking about strategic product rollout or rating, or different methodologies or algorithms that they're using, whatever it is, that could be a trade secret compromise that simply is not getting disclosed to shareholders and is supposed to be under this new cybersecurity disclosure rule, which means that boards of directors are vulnerable for violating this. And directors and officers, liability insurers are starting to pay attention to this. But it really is a significant issue that I think a lot of public companies are overlooking. The next thing, and because we're in a hurry, I'm going to just breeze over this. I think most organizations know that the FTC was potentially set to ban, or did try to ban non-competes at the federal level. That has been delayed. We'll see what happens after this election, but there are a lot of state laws in any event that are limiting the use of non-competes or banning them altogether, with the idea that they prohibit or limit fair competition. And so a lot of organizations used to rely really heavily on their contractual agreements with employees and third parties who had signed non-compete agreements, and would use that as a really heavy stick following the theft by an employee or former insider of a trade secret. That could still come into play, but you need to do a lot of other things to protect your trade secrets. We'll just have to leave it at that. Next slide, Nikki. We talked about this a little bit already, but the patent system in the United States is really struggling at the moment. It's difficult to get patents approved. They're expensive. The PTAB, sadly, is being inundated with cases where they're asking for the overturning or invalidating of a lot of patents that had previously been approved, and the overturn rate is huge. And so for all the reasons that Nick and I have already talked about, and a lot of other things, but mainly significant challenges with the patent system, we're seeing a dramatic shift towards trade secret protection. The other big issue is that so much of today's technology really can't even be patented. And we could spend a long time on whether or not generative AI output really is or is not created by a human. But so far, the courts are saying that it's going to be difficult to grant patent or potentially copyright protection around generative AI output because of who created it and whether or not it was created by a machine. So there's a lot going on environmentally that's causing this shift as well.
And
Next
Mary,
slide.
if I could just chime in quickly there, just really quickly, also, it doesn't mean that, companies should not get patents at all. However, a comprehensive IP program takes into account both patents and trade secrets, because often you can patent an aspect of, say, a device, but maintain other highly important and valuable aspects of the device as a trade secret. So you can have both. And so you need to work with your IP counsel on a comprehensive strategy there.
Absolutely.
Thank you.
I would just chime in. The other way to think about it is, I have clients that have 200 patents, but none of those patents get them to market. They fit together through sort of a connection of a program of activity that allows them to implement them. Those connections are the trade secrets. Those things that run the patents, that make the patent work, that get the patent to market, that make it affordable, that's why every company that has patents has trade secrets. And
Yep.
those are a huge part of the business.
Absolutely. Next slide, Nikki, and we'll zoom through a couple of these because I want David to talk about some actual cases. But essentially, this is just meant to describe how trade secret misappropriation works and what it results in. You have a trade secret that is an innovation or idea or know-how that's been created within the organization that gives you a competitive advantage. Somebody walks out the door with it, whether that's a competitor who's hacked in or former employees who have taken things inappropriately. That results in the direct loss or sort of invalidation of or sunk costs that you spent on all the R&D and development to get to that stage, including all the negative know-how that that your competitor does not have to invest in, and the sort of indirect loss of the future value of that asset if it no longer is solely yours and it's available for competitors to use. When the information about a trade secret misappropriation, especially a crown jewel trade secret, becomes public, that's when you're going to have damage to reputation, potentially some additional loss of market share, drop in stock price, D&O claims, et cetera, et cetera. So it really is a very big deal when the trade secret that's misappropriated is valuable to the organization. Next, Nikki.
There's a question in the chat that I think is a pretty important one. I don't know if you want to talk about it, but it's about what's the best way to document and manage trade secrets and educate employees. And to me, it's to implement a program on the front end that identifies what those trade secrets are and how they're going to be kept as a secret. Obviously, the insurance company is going to be a big part of that if you choose to insure them. And the education, I think, is something, if you reach out to some of the counselors that do this, we already have and have been hoping to have clients ask us to come and train employees in a fairly brief manner about what to do and what not to do. Some of these obviously are a need to know thing. Only a few people will know what the secrets are, but it shouldn't be that difficult to explain to them that these are the secrets. Everyone at Coca-Cola knows not to take the Coca-Cola formula, which is not just the recipe, but how the Coke is made. And you can do that with your company.
Yeah, that's right. And that's something, we do regularly, all three of us, is that sort of counseling, but also training. As David said, it's very easy to come in and do a training for your employees as to what a trade secret is, what protocols are in place and need to be followed to protect the trade secret, and what sorts of reporting needs to be done if an employee thinks there's an issue concerning trade secrets. That's something each of us would be happy to speak more about.
Yeah, we actually included training, 12 training videos in something that we just rolled out called Trade Secret 101. It's a little consulting package that's literally meant to help people get started down this path. It's not as comprehensive, Nick or David, as to what you guys would do in terms of reviewing the actual wording and the non-competes and non-disclosure agreements and those types of things, but it's meant to just give a framework. And the videos are, I think, fantastically done. We partnered with a company out of the UK to do those with us. And so anyway, all three of us can help with that. And we're hoping that people will ask us to help them with that. David, if you want to walk through this, that would be fantastic. Just in terms of giving the companies on the phone a sense of what happens when you don't prepare, when you're not ready, and you don't have proper evidence to bring a misappropriation claim. And specifically Alcoa versus Alloy, Universal Alloy would be great.
Yeah, I think I have a couple of slides that apply to that case specifically. If you want to put, there's one where it has the wing spar on there, I think, that are in the deck, but if you want to put that up. But Alcoa versus Universal Alloy. I'm in Georgia, in Atlanta. This was a case in Georgia. and it had to do with the design of wing spars, which are the long things that make a wing sturdy. They go the length of the wing, etc. There were no patents involved, and this company, which was an Alcoa subsidiary called Arconic, their whole business was making wing spars for one company, Boeing. At a certain time, a bunch of engineers left the company and downloaded many, many gigabytes of basically all of the stuff that they were working on, and went to a new company called Universal Alloy Corporation. 6 months later, Universal Alloy got Boeing's business away from Alcoa, leaving them with no clients and no customers, and they filed a lawsuit in 2015. The case went to trial in 2023. There were 8 years of litigation. You can only imagine the millions and millions of dollars that were at stake. They claimed $200 million in damages at trial. I know the lawyer that tried the case. He's very good. However, the defense was good too. And, this company had not done what we're saying you probably ought to do. There was no list of here's the stuff in our wing program, our SPAR program, that is really, really important and that nobody can know about, et cetera. They had NDAs, but those NDAs weren't good enough. They weren't very good. And eventually, when they went to trial, the defense sort of poked at various features. Well, this is on the internet, that's on the internet, you didn't really explain what this is, et cetera. And at the end of the day, the jury found that Alcoa did not own the information. Literally, they just said, it's not yours. They didn't really explain what that meant, but that's the way jury verdicts go. The jury makes their decision, they sign the paper, and the case is over. So they lost what they argued was $200 million. I know that even with motions, at least $90 million of damages got to the jury to consider, and they said no. So this is the worst case scenario of a company not protecting everything that its business meant and letting it go out the door. And this is also the classic and most common way that trade secrets go away, is through insiders leaving and taking them with them. In the Appian case, a similar story, except it was a software. In order to essentially steal their rival's program, they went through a customer and a licensor and sort of hired that person to help them figure out how the other company was doing what they're doing. Eventually, there was a $2 billion verdict, which has been reversed and sent back down, but also with a finding that they did prove trade secrets, and they do have trade secrets as a matter of law. So that's more of a win for the plaintiff side, and they had a better program. They had non-competes. They had shown that they had taken a lot of measures to try to prevent licensees from having the source code and so forth.
And I think on the Appian, just kind of a quick note on the damages. It was a massive number, over $2 billion. $2
billion.
That did get sent back down on appeal. You do see some very big numbers in trade secret litigation. You see big numbers in patent litigation as well. But you do see sometimes the appeals court or the judge, after seeing the jury verdict, knock it down. So from a litigation perspective, it's good to think about, if you put up a big number and you get a settlement offer that may be palatable, it's something to consider when we're seeing some of these really big jury verdicts kind of get kind of brought down to size a little bit on appeal or by the judge on review. So just quick practice note there.
Yeah.
Interesting question that we have. It says, do you think it would be prudent for employers to give employees a percentage of profits and explain the correlation between protecting the company's trade secret and their share of profits? I will say that I know of one large public company that they have a patent program, of course, where if you have an invention, you get a bonus. They sort of have that, straight as part of the compensation for their R&D, et cetera. They also have a trade secret program. If you think that you have invented or created, or that you're, sort of responsible for a trade secret, there's a form that they have. You fill out that form, and it's not $1 million, but you can get cash from the company if they decide, yes, this is a trade secret, and they put it in the folder where they keep their secrets hidden. And it's an excellent program. It's one of the leading hard drive manufacturers in Silicon Valley, and there are some companies that do that. I think it can't be more than 5 or 10%, though.
Yeah,
I would
that's
add
right. Oh, sorry, go ahead, Mary.
Sorry, that I am a strong proponent of that personally. I mean, I think about, I worked for insurance brokers my whole career until I started my own company. And the bonus compensation program, to be candid, was very, very slanted towards sales. In my humble opinion, in today's environment, the people who are creating the significant competitive advantage value for your organization deserve bonuses equal to or greater than the people who are selling the products. And so it's a radical idea. I love it. It's a great way to incent people to not only continue to develop things that may not be patented, but also to understand the value of keeping them secret. So I really like that idea. I wanted to add, because we need to move on, but I wanted to add, and I can see that we have a couple questions. We will definitely get to a couple more of those. But on the Appian versus Pegasystems, two really interesting things happened there from an insurance perspective. One, when the original verdict was handed down that was north of $2 billion, Appian, who won that case, purchased a basically jury verdict protection insurance policy to the tune of $500 million, which is super interesting. Essentially knowing full well that a lot of these cases result in the damages awards being minimized or sort of decreased on appeal. It remains to be seen ultimately what the damages are going to look like in that case, because it's going to have to be retried, as David said, but it'll be interesting to see how the insurance pans out. I don't think that anybody else is going to be stepping up to write those policies and trade secret claims anymore, because the market's going to get clobbered. I think that was a test the waters kind of thing. As importantly, though, I do think that this is going to continue. There was a directors and officers liability tag-along claim resulting from the stock drop that Pegasystems saw when the award was announced. That was largely based on the fact that Pegasystems, who was the alleged trade secret misappropriator, told their shareholders, yes, we have this litigation pending, but it's a nothing burger. We didn't do anything wrong. We're very confident in our case, blah, blah, blah. Boom, $2 billion verdict against them. And the shareholders were caught completely off guard and very unhappy, which again gets back to why the SEC is concerned about this and wanting organizations to disclose what they're doing to protect these assets and when the assets go missing. So it's really an interesting sort of insurance discussion around all of this and what plays in there. Next slide, Nikki. And David or somebody, if you wanted to read questions while I'm just going to walk through this really quickly. I think a lot of we're all saying the same thing, but this is something that we call trade secret asset risk management. We just insert the word asset, slightly different than what Nick calls it, but it's really the same process. This should look really familiar to anybody who's involved in enterprise risk management within their organization, because ERM basically follows this around every potential exposure that faces an organization, whether it's property related, a first party related or liability related, meaning that the first thing you do in a prudent risk management program is identify and document the existence basically of the risk itself. So the second thing that you do is, once you know what the risk is or what what assets are at risk, then you determine how valuable they are. Because only once you know how valuable they are, and this does not need to be to an exact dollar amount, but certainly at least relative to other assets that you're trying to insure, or manage the risk around, then you can apply proper countermeasures. And then you can insure them. But the interesting thing is that in trade secrets, it's literally the only asset class I've ever encountered in my entire career where people start with step 3 and just try to throw risk mitigation strategies at the wall and see what sticks. And they use what they're doing for privacy, personally identifiable, and PHI, and trying to apply that to trade secrets without identifying and documenting the existence of trade secrets or figuring out which ones are more valuable first. And the reason those 2 steps are important is because you cannot monetize them, as David was saying earlier. If you don't know the value of those assets, you can't license them. But as importantly, you can't insure them. And insurance, to me, is a game changer in this space. This is the first time there's ever been insurance on the value of innovation and ideas, trade secrets, if they're misappropriated. And if you insure those assets, now you can leverage them for capital raising. You can leverage them for getting loans against the value of that insurance, the proceeds being essentially the collateral if there is a misappropriation event that devalues your entire company, but certainly devalues the asset. So this all plays into trying to help organizations think of trade secrets truly as assets, because they are. And they can be treated as assets. Why are they insurable on a first party basis where we can actually insure the value of them versus other types of IP? Because they're secret. So we can use the trigger of the insurance as a disclosure of that secrecy. Once the secrecy is gone, now we can try to recapture it and help you recover using crisis management tools. And the law firms that we have on our panel, 2 of them on the call here today, we'll do a forensic investigation to determine the source and scope. But by that point, we will have already identified what the most valuable trade secrets are for your organization and documented the existence of them, because we do that as part of the underwriting process. So you'll be much, much, much better off having gone through the due diligence and risk management process, even if you don't buy the insurance. Next slide.
Can I jump in?
Yeah.
Can I jump in just for a second? So a lot of questions about what should be in an NDA. And what Mary's saying, in my opinion, is that that's step 3. And the people are a lot of my clients and companies, and it's good to have an NDA, but what they do is they'll write an NDA, and virtually anything that you could imagine is in the NDA. Yeah. And it's very broad, and that's a very thin blanket over your actual sort of secret sauce. And it's what I would call a ready, shoot, aim method of going about it. And I will ask clients, what is it that you're worried about? And what are your secrets? And they're sometimes loath to, or cannot articulate those things. There's another case in Georgia where a judge looked at an NDA and he said, taken to its logical conclusion, anything in the company, every item of information is covered by the NDA. It's unenforceable. And that salesman walked out with millions of dollars of business in hand, in his briefcase, no questions asked, no trade secrets, nothing. That's called the Mercer Advisors case, and shocking result, but a warning. Now, there is some thought that goes into what should be in your NDA, and the best thing would be, what it really is that you're worried about. You don't have to spell out the formula or anything, but you could say it's the formula. It's the information that goes with it. It's a state by state issue, and the guy Nick and I can help with those. We do those all day long, but we also face defending clients who have very bad NDAs and no program, and it's expensive and not a lot of fun to try to defend that sometimes.
That's absolutely right. And kind of the other side of the coin on identification of trade secrets is, if you do need to go to litigation, you are going to need to provide the court some sort of identification of what was taken. And it needs to be reasonably specific so as to identify for the defendant what he or she is accused of taking. And not infrequently, plaintiffs do not or are not able to adequately disclose or provide to the court a description of what has been taken, and those complaints are dismissed. Now, the plaintiff may get another shot, but maybe just one more shot, right? And these are high stakes and very expensive processes. So you don't want to be in that position where your complaint, you've gone through a motion to dismiss and your complaint has been dismissed, and you've spent many thousands of dollars just to start all over again. That expense can be eliminated by taking this step before any litigation is on the horizon.
Absolutely. Let's go to the next slide, Nikki. I know we're running short on time. I appreciate that. So let's talk for a second about what is not a common misconception. So trade secrets are an asset. We've established that. They're an intellectual property asset. They actually have value. You can put a value on them. What we would say is that certainly the value includes at least, at the very least, the costs that you've spent developing something, including all the negative know-how and wrong turns that you've made. And it includes the potential future value of that asset brought back to net present value. And that value can be tied to potential licensing of that technology or innovation, or it can be, measured in several different ways. But essentially, there are valuation firms who do IP asset valuation for a living, usually looking at an entire portfolio for tax purposes or for M&A transactional purposes. But we've asked those organizations to repurpose what they do to look at an individual asset that we and the client have decided is a trade secret based on the protections around it and that it meets the other criteria, and help us put a value if we want to schedule that on the insurance policy. Now, that works just like any other insurance, any other property insurance, but it essentially tries to convert, or for insurance purposes anyway, converts that scheduled valuable asset to a tangible asset, so that if it's stolen or misappropriated, if we're not successful in getting it back, which I talked about the crisis management earlier, then the policy pays the actual damage. Why did we create this policy? Because 90% of the value of the S&P 500 now is said to be in intangible assets. The vast majority of that could be classified as a trade secret. We think it's a $35 trillion, trillion with a T, uninsured asset class, because the insurance industry covers tangible property, obviously, and cyber policies, which are really the only other insurance that tries to cover on a first-party basis the value of information or data, only covers the cost to recreate data. It does not cover all of the money and time and expense you put into developing something that now has been shrunk down into a data set or a piece of paper. There's no value in that, really. For a lot of organizations, and cyber policies are not intended to cover that. They will either specifically exclude it, or the valuation clause will make it very clear that the only thing that's covered is the recreation of data. And so essentially, we're trying to create this because of the gap in cyber. Crime policies cover theft of money and securities, not intangible property. In fact, there are IP exclusions very boldly written into most crime policies. D&O policies will respond to cover the board of directors and potentially the entity for shareholder class actions that follow a drop in stock price, but they never cover the value of the asset or the lost revenue of the potential future value of the asset. So this is literally, trade secret insurance is the only insurance in the world that covers the value of these assets, which is critically important for both investors and the creators themselves. Because in the venture capital space, we talked earlier about what's going on with Hone Capital and how that's a terrible situation. But if you've just given a company $10 million for them to go continue inventing or creating something that's going to be the next greatest thing in solar energy, 3 engineers walk out the door 6 months later and take all of that information with them. If you are not able to pursue that and enforce your trade secret rights around that asset because you haven't identified or documented its existence or shown that you limited access to it to only people who needed to know, et cetera, then the the company value has just fallen through the floor because trade secrets can never be recreated, or you can't ever get the value back of a misappropriated trade secret. And that's why the insurance is critically important for investors. Next slide, Nikki. Nikki, next slide. She might be having some trouble there. I'll go ahead and speak to it. The next slide, we were just going to talk about basically the scenarios on how the insurance works. I've given a little bit of that already, but just given some detail. But if you had a $20 million asset walk out the door, you hadn't identified it, you might try to bring a claim against a third party. And we've got dozens of lose-lose-lose scenarios, much like the Alcoa case that we went through earlier. And where we can show that a company couldn't prove the existence of a trade secret, couldn't prove that they independently developed it, or couldn't prove that they put reasonable measures around it. So if status quo is to wait and try to litigate, not a great strategy unless you have a really, really robust risk management program. And even then, the cost to litigate a trade secret claim from soup to nuts or start to finish is $4.1 million. A lot of companies, especially in the SME space, do not have that kind of money. So it makes sense, just like any other valuable asset, to potentially insure it. And then the next slide talks about how that would work if you had bought the insurance, and essentially a recovery based on, $1 million in premium roughly for 20-ish million in limit. But that's a gain of potentially $24 million from the insurance company had you followed the processes that we require during due diligence and underwriting and bought the insurance. Anything else? I know we've got a couple minutes left, and there's some questions. I can't really read those because unfortunately I have to be on my phone today, because I was up here avoiding the storm in Miami. But Nick or David, if you want to read and see if there's anything else that we need to talk about. I know that we started a couple minutes late, but if anybody wanted to ask something, or you want
to know where to get the videos and that you were mentioning, the Trade Secret 101 videos.
Okay.
So
that the Trade Secret 101, just email us at info@crownjeweliinsurance.com, or just email me directly, mguzman@crownjeweliinsurance.com, and we will send you some information about that and schedule a call. That is part of our Trade Secret 101 package. And we're happy to share those with you.
There's also another question
had to do with IP-backed loans and financing rather than prepping for litigation if they have trade secret insurance. And I'm not sure who has that thorough and good of a trade secret insurance program to test that, but it's an interesting, that's good thinking on where companies should go with it.
Say that again, David.
Do you see companies that have trade secret insurance for IP-backed loans and financing rather than prepping for litigation?
Well, that's where we want this to go, actually. We are talking actively to several lenders right now about whether or not and how we can make this a prerequisite to them loaning money against the value of trade secret assets specifically. We think it makes perfect sense because it's just like being able to extend a mortgage to a company that has, or a loan to a company that's got a lot of oceanfront property. The timing of this discussion is interesting given the storm that happened last night. But essentially, the only way you get a loan is to show that you have wind, flood, and storm surge coverage if you've got oceanfront property. And the only way to get that insurance is to show that you have all the proper building codes and regulations and proper windows and essentially all the COPE information in the property insurance speak that makes sense. That's effectively what we're doing, is we're covering the only hazard peril that can decimate the value of a trade secret by covering theft of a trade secret asset with this insurance, but you can only get it if you have a good risk management program. And that's what we're here to do. If anybody wants to talk to a lender about loaning against their trade secrets, we are happy to get on the phone with you to talk to that lender, because I'm pretty sure we can talk them into this. And, you know, sort of, that's really all for today. There's the information on all three of us, and how to get in touch with each one of us. Any other questions before we hang up, David? Anything else that you can see up there that we didn't answer?
I would say if you knew that you had 100 pounds of gold dust floating inside your company, what would you do to try to hoover it up and make it into an asset? That's kind of what trade secrets are. It's sitting there, and a lot of people aren't finding it.
And almost every company has some of that gold dust. Don't forget it. You just need to look a little bit, but there's some significant value that can be driven through these programs at relatively low cost up front.
Exactly. The whole point of this is, you know, especially with the insurance, is not only are we protecting your bottom line and providing coverage for the value of the assets, but allowing you to monetize them for the first time ever, really. Along with some of the, you know, the strategies that Nick talked about earlier, which is licensing and other things. So we really appreciate everybody's time. Appreciate the support of the USIPA and GIPA and the global IPA for letting us do this. And, you know, again, we're really wanting to get the message out that it's not that difficult to change and tweak just a few things that most companies are already doing to be able to put reasonable measures behind some of these assets. And there are some really good and relatively easy to adopt ways to identify the assets in the first place that any of us would be happy to talk to you about. So thank you very much. This is being recorded, and we will certainly post the recording for people who wanted to share this with others. And we appreciate everybody's time.
Thanks, everyone.
Thank you.
Thanks, everybody.